The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law. I hope you find this video and podcast helpful. If you need some help, please feel free to call us at 630-324-6666. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. We serve all of Illinois, and we're also happy to meet with you and provide most legal services virtually without requiring you to leave your home. Enjoy the video.
Hello, my name is Matt, and I will be talking about recent changes in Illinois landlord tenant law. The most drastic changes in landlord tenant law have been due to the worldwide COVID-19 pandemic. March 2020 saw the shutdown of the courts, schools, and other non-essential businesses for an indefinite period. It is also during this time that Illinois Governor J.B. Pritzker, through an executive order, announced a moratorium on residential evictions. Due to the COVID-19 pandemic, many tenants saw a decrease in work hours or were laid off and could no longer pay rent. As the pandemic wore on, landlords, especially mom-and-pop landlords, could no longer pay their mortgages on the property due to a lack of rental income stream. In this situation, under the eviction moratorium, tenants did not pay rent and landlords had no ability to evict tenants. In June of 2021, Governor Pritzker issued an executive order that carved out some exceptions to the eviction moratorium. The executive order outlined who was eligible to be a covered person under the order. The executive order permitted an eviction action to be filed against a non-covered person. This executive order was still not enough to relieve landlords of their financial woes due to the moratorium. The Illinois Housing Development Authority, or IDHA, was able to bring some relief to cash-strapped landlords with grant funding. The grant would provide up to a year's back rent and 3 months of rent going forward. Both the landlord and the tenant would have to fill out the application, and if approved, the funds would go directly to the landlord. The program brought some financial relief to the landlords and prevented a tenant from potential homelessness. Another change has been made to eviction courtroom procedures since the COVID-19 pandemic occurred. In Cook County, a free mediation program called the Early Resolution Program, or ERP, was initiated. Now when an evictions case is filed in Cook County, a judge will often grant a defendant who does not appear a week-long continuance to appear in court. If that defendant appears on the next court date, it will be continued for another week, so that the defendant can consult with free legal services provided by the ERP program. If the defendant does not appear on the first court date, a continuance for a week will usually be granted so the defendant can review his or her case with the ERP attorney. The goal is for the ERP to provide a resolution for the plaintiff and landlord. DuPage County also has a similar mediation program established pursuant to Article 14 of the DuPage County local rules. The biggest change to Illinois landlord tenant law is Governor Pritzker's executive order that repealed the eviction moratorium as of October 3rd, 2021. Now, eviction cases can proceed as they did prior to the COVID-19 pandemic. Although the moratorium has been repealed, things are still different, like the mediation programs in court. Another change was a new source of grants backed by the court system. The court-based Rental Assistance Program, CBRAP, was initiated in the circuit courts, except for Cook County, which has its own court-based rental assistance program. The CBRAP program is similar to the IDHA program. Both landlord and tenant must apply, and the grant would cover 12 months in back rent and 3 months in prospective rent. Finally, the other notable change is the enactment of the Cook County Residential Landlord Tenant Ordinance, or RLTO, that became effective June 1st of 2021. This ordinance is modeled on the City of Chicago's RLTO ordinance. The ordinance is very tenant-friendly and imposes hefty fines on landlords that do not adhere to the strict requirements of the ordinance. The ordinance requires that landlords maintain the rental property in a habitable condition, such as providing hot water, running water, heat, plumbing, and even internet access, if it is to be provided in the lease. Thanks for watching. To learn more, check out our article linked below, and be sure to leave any questions you have in the comment section, and subscribe for more legal content daily.
Hello again, this is Kevin O'Flaherty from O'Flaherty Law. I hope you enjoyed the video and podcast. If you did, we'd love it if you'd subscribe to our channel. If you need legal help in this or any other area of law, please do not hesitate to reach out and schedule a consultation. Most consultations are free and all can be conducted remotely if you'd like. Please email us, book online, or call us at 630-324-6666. We have many locations for your convenience and we serve all of Illinois. So thanks again for watching.